Welcome to another in the series of NJAPM webinars. I'm Carl Cangelosi, and today our program is Privilege, Confidentiality, and Agreements to Mediate in the Age of the Coronavirus. Today our co-presenter is Bruce Matez. He's been practicing divorce and family law for 30 years, primarily in Camden, Gloucester, and Burlington counties, and has been a mediator for 25 years. His firm BorgerMatez has offices in Cherry Hill and Woodbury. He's practicing alternative dispute resolution full-time now, including mediation, arbitration, and collaborative divorce. And welcome, Bruce.
Thank you.
Everyone should know that we have 61 people registered for today's webinar. That's a record number. And this morning I was having coffee with my wife and I was telling her that, and she said, well, what's the topic? And I said, well, it's about the Uniform Mediation Act and privilege. And she said, that's unlikely the reason. And then I said, well, maybe it's because it's Bruce and I presenting. She said, no. And I didn't think that was fair because she doesn't know Bruce. And then she said, probably people have watched too much Netflix and are bored and they have need something to do. In any case, it's a record and we're very pleased. So today we have sort of three parts to what we're doing. The first part is I'm going to be doing a short presentation on the Uniform Mediation Act and be using slides to do that. Please, during that event, if you want to ask a question, use the Q&A function at the bottom of your screen. Do not use chat. Do not raise your hand. Bruce is then going to go on to the second part and talk about agreements to mediate, what should go in there with respect to privilege, confidentiality, and so forth. And the third part is we're going to pose some hypothetical questions. This is going to be interactive. So at this part, once we ask a question, and if you want to answer the question, raise your hand. I will then unmute you or give you the ability to talk. You have to unmute yourself, and then you can talk and we will have a discussion about the question and your answer. So with that, let me go to the first part, and I'm going to share my screen. And let's see. So I have to go back to the beginning. Okay. Sorry about that. Okay, so this is the first part. And we're going to be talking about the Uniform Mediation Act because that's where privilege originates. And these are all the sections of the Uniform Mediation Act. We're not going to cover them all. So what we're going to do is the first thing are the definitions. And these are obviously very important. So the first one is a mediation communication. And it means a statement, whether verbal or nonverbal, or in a record that occurs during a mediation that is made for the purposes of considering, conducting, participating in, initiating, continuing, or reconvening a mediation or retaining a mediator. So we'll talk about that a little later as to what could be a mediator communication. A mediator is the person who conducts the mediation. A mediation party means a person who participates in a mediation and whose agreement is necessary to resolve the dispute. Those are the parties. So in a divorce, that's the husband, the wife. In the civil matter, that's the plaintiff, the defendant, etc. A non-party participant means anyone else, any other party who participates in the mediation. So it could be, for example, an expert that's brought into the mediation. It could be the husband of the father of the spouse, or the father of the husband. It could mean any other party that is actually brought into the mediation. So What the UMA does, it creates a privilege against disclosure, admissibility, and discovery. So a mediation communication, as we talked about before, which is a communication, is privileged and cannot be used in a court proceeding. Now, there are exceptions to that, but generally speaking, it's privileged. So for example, anything that I as a mediator put in writing is a privileged communications. Anything the parties put in writing or orally said to me as the mediator is a privileged communications. If, for example, I prepared a document which I presented in mediation, it would be a privileged document. Now, if I prepared that, say, using all the information that the parties gave to me that went into a balance sheet, so there would be statements from banks, statements of stock accounts, et cetera. The underlying information is not privileged, but the document I prepared would be privileged. So, now how do these privileges apply? They apply in the various ways, these ways. A mediation party may refuse to disclose and may prevent any other person from disclosing a mediation communication. So that's what a mediation party can do. A mediator may refuse to disclose and may prevent any other person from disclosing a mediation communication of the mediator. So I can't prevent, say the parties agreed that they were going to go to court and they wanted to disclose documents or communications they had between themselves. They can do that. What they can't do without my permission is to try to get into the court proceeding anything that I said or any communication of mine. They can't do that. Now, understand that a mediator privilege is somewhat unique. In most privileges, say a attorney-client privilege, a mental health professional client privilege, the privilege belongs to the client. And so the client can tell the lawyer, tell the mental health professional, no, you have to talk. If you go to court, here the mediator has an independent privilege and may refuse to go to court and may prevent others from disclosing his or her mediation communication. A non-party participant has the same privileges as a mediator. So if you bring an expert or anyone else into the mediation, that person also has this privilege and can do this, can also make the same refusals that a mediator can. Now, each of the above can waive their privilege. So if a husband and wife say, we want to go to court and we want to disclose the communications they will have had, they are quite free to do that. A mediator can do the same thing, and we'll have a question about that later. Now let's see. Yes.
Carl, there's a question that I think you might want to address from Art Lieberman, that this privilege that you're discussing right now only is related to disclosures to the court. It has no bearing on disclosures to other people, which I think you're going to get in the confidentiality conversation in a few minutes.
Correct. So,
okay.
And I'll talk about it really at the bottom of this slide or the next slide. So then we get to confidentiality. What does it say in the Uniform Mediation Act about confidentiality? So it says, unless made during a session of a mediation which is open or required by law to be open to the public, which is not any of the ones we normally do, mediation communications are confidential to the extent agreed by the parties or provided by other law or rule of the state. So that's all it says. It says confidentiality is created and governed by whatever the parties do. So what's the relationship between privilege and confidentiality? There is no relationship. One is created by statute, that's privilege. The other is created by contract between the parties. Whatever you create between the parties doesn't necessarily affect the privilege. And we can talk about some of that later, but the two are independent. So for example, if you had no confidentiality at all, you would still have privilege. Okay. So that's what I've just said. Created by law under privilege, confidentiality is created by contract and relates to what happens outside of the court. Okay. Any questions on that? So please keep in mind, two different things. One's in court, one's outside of court. Okay, now I'm going to stop sharing, and Bruce is going to go on to his part.
Okay, Carl, just confirm for me you can see the beginning of my slides.
I can.
Okay, so before I start, I'm going to ask to do a little poll here of how many people in the room, and you can raise your hand virtually, how many people assure that they have a signed mediation agreement before they begin their first session? I'm just waiting for it to let me know. So I've got about 15, 16, oh, it's going up.
Yeah, it's really filling up. I don't see anyone who doesn't.
Okay. The other question I wanted to ask is, can we stop that? Carl, I'm not sure how to do that, do you?
Yeah, I do. Okay, I lowered all hands.
So how many people have two different provisions in their agreements, one related to privilege and the other related to confidentiality? So if I'm getting this correctly, 7 people raised their hands out of what looks like over 40, and now we're up to about 9 or 10. So it looks like a majority of the people on this webinar do not have separate provisions. And I will admit that until Carl taught me a little bit about this in preparing for today, I did not have 2 separate provisions in my agreements. And starting this week, there will be 2 separate provisions in my agreements. So we're going to talk about what you need to put in your agreement. If my computer will let me do that. There we go. So you really do need to have 2 separate provisions in our agreements, one relating to the statutory privilege and the other related to confidentiality. And you know, historically, I think many of us had one provision related to confidentiality, which probably dates back to prior to the UMA being passed in New Jersey, which was around 2004. And perhaps maybe, I know for myself, I just never really modified my agreements. So from a standpoint of the privilege, I think it's important to reference the Uniform Mediation Act in the agreement and paraphrase the statute, explain to people what the privilege is in plain language. I also think it's important to define any additional rights that you want to assure. So for example, do you want to expand the statutory requirement by agreement that there will be no disclosure at all, whether or not the parties want to have disclosure? Do you want to add some provision for legal fees if one of the parties attempts to require you to produce documents or appear in court? And do you want to include something about compensation for your time if you are asked to produce documents or appear in court by the parties or by one of the parties. I also think it's important that you explain the waiver and exceptions that are in the statute in relation to that privilege. I think this is a very important concept for people to understand, that there are certain things that you have a duty to report under the statute if they come out during the mediation.
Bruce, I have to tell you, I would think that, in my opinion, that would make the agreement or those provisions rather long. So I don't explain all of them, but I do reference it in certain respects. And if we have time, I can go over the relevant provisions that I would put into my agreement to mediate.
Right. Yeah, I'm not suggesting you go into detail. I think it's important to note them. I also I also go over that with people in the beginning of my first session. As part of an introduction, I explain again to them these concepts, which we'll talk about in a few minutes. In terms of confidentiality, which again is a separate provision, there's Rule 144D, which pertains to the court-appointed post-MESP mandatory economic mediations. And the question that has arisen is, do those confidentiality provisions from Rule 140 pertain to private mediations? And I think the answer to that is no. I think they are very specifically drafted for the court-appointed mediations as part of the complementary dispute resolution rules. That is not to say that one might not make an argument at some point that they should, or that they should, but I don't believe the rule requires that they apply to private out-of-court mediations. So when you're drafting your agreement or you're modifying your current agreement, the question is, what do you want to define as confidential for your purposes and the purposes of your clients? So do you want to restrict disclosure to third parties other than their attorneys, mental health professionals, and experts? Somebody raised the question before, can you restrict confidentiality for family members or other people? I believe you can restrict that in your agreements. It depends on what you wish to do. Do you want to allow for or restrict disclosure to family members or other people who provide emotional support or financial support? You know, sometimes you have a parent or a brother or sister or a new significant other who is financially paying for the mediation and paying expenses for a particular person, and the question might come up. Sometimes one of the parties says, I don't want disclosure to this person, or I don't want them to know what we're talking about. I actually have a private mediation going on right now where there's a parent involved, and one of the parties is hesitant to have the parent know what we're talking about in our mediation sessions. I think it's important that your agreement reflect your ability as a mediator to confer with the party's attorneys if they have attorneys. What are the limits of your ability to confer with them and talk to them? And then I think there should be some clause into what if one or both of the parties don't agree. Sorry, no, back that up. The question becomes, what if one or both of the parties don't agree with your confidentiality provisions? And I'll give you my own experience. I recently had a client in a private mediation who sent me my agreement with substantial revisions, including substantial revisions to the confidentiality provisions. I wrote him back a very nice email and said, I don't change the provisions of my mediation agreement. If he wants to have a different provisions, he should seek out a new mediator. I take the liberty of being able to decide what I'm comfortable putting into my agreements and sticking to that. I also think it's important that you provide a provision about the confidentiality of your caucuses. Clearly define in your agreement how you're going to handle them from a confidentiality standpoint. Are they confidential? Are people allowed to tell you something in a caucus that you are going to keep secret or confidential from the other party in the mediation? And I know from having these discussions over the years with many different mediators and being at different seminars and workshops about it, I think we all approach that subject very differently. My own personal view of it is I do not allow people to tell me something that they want me to keep confidential from the other party. And I make that very clear to them in my agreement and in my introductory letter and in my introduction at the beginning of the mediation and when we go into caucus. I want to make sure I highlight it every time I have a chance. I do let them tell me about settlement positions without necessarily saying I'm going to disclose them to the other side. It's really a matter of facts. But your caucuses still remain subject to privilege. That is a statutory provision. But the confidentiality of them needs to be defined because that's a contractual obligation or a contractual determination. And I think your agreements should also address under what circumstances third parties are allowed to participate in your mediation. And I suggest that if there's any third parties participating other than attorneys, I require those people to sign mediation agreements. If we bring in an expert who's going to participate and we want it to be part of the process, I want them to sign the mediation agreement. I want them to also be subject to the confidentiality. My feeling is anybody that sits in the room should be subject to confidentiality of the process. So here we are, almost 7 weeks into, or close to 8 weeks into this coronavirus pandemic. And most of us, if not all of us, are doing these mediations virtually. So I want to talk a few minutes about privilege and confidentiality in the virtual setting. So a couple things that I've learned over the last couple of months, I think will help. I don't think there's any magic formula to this, but requiring people to identify themselves before they are admitted into the room. This morning, I had a mediation with someone who was using their child's computer and they were logged in as their child, and she didn't know how to rename herself. So explaining to people how they can rename themselves so that they put their actual name in and you're clear that that's the person you want in the meeting. I recommend that you enable the waiting room in your settings. I actually think that is an automatic setting in Zoom now, but I'm not sure. And that you admit both people at one time in the same way that you would in your office, to not sit down with one party, not invite one party in the room before the other person arrives. Same thing applies to the virtual setting. I think it's important to make sure that third parties do not have access to what's going on. They can't hear what's going on, and they're not watching or observing. And I think it's important to put that kind of language in your agreement that specifies that nobody else is going to be in the room with the person who's participating within earshot or be able to observe. I think it's important that you restrict video or audio recording. This is wrong. I'm sorry. I don't believe you can control it. There should have been a can't there. I do not believe as a host you can control whether somebody audio or video records this session. And quite frankly, if they really want, somebody can hide their phones and hold them like down a little bit and record the whole thing on their cell phone as it's going on. So there's a limit to what you can control and you can't control. I put it in my agreements now that there is no video or audio recording. I've seen some other people who've included in their agreements that there's no video or audio recording without consent or permission from the mediator. I'm just never going to consent or give permission to anybody to do it, so I don't even put that in there. And my partner raised this with me, Gary Borger, raised the concept of allowing people to take photographs or screenshots. And I am now putting in my agreements that there are no photographs or screenshots permitted. I think, again, some people are saying that it's okay with consent of all the parties who are participating. I just don't think it's necessary. I can't think of any reason why anybody needs to take a picture of a mediation setting. So this is sample language that I've put into all of my agreements. Just reiterating that the privilege and confidentiality is applicable to virtual sessions. No person other than the participants may be present in the room. No person who's not an approved participant may be located in a place where they can see or hear the virtual session. And again, this is just suggested language. It's just what I wrote in conjunction with my partner, Gary. I'm sure there are other people who have similar provisions or maybe even more in-depth provisions. And a little bit more in terms of the virtual setting, in terms of procedures. I think it's important that you set out for people how they're going to do this, what the process is. So the first is really how they're going to sign the agreement. This wouldn't necessarily go into your agreement, but it needs to be communicated to them. I am now doing all of my mediation agreements digitally. I'm using Docusign, and it is very simple to use, and it sends the agreement around. Everybody signs it digitally. It date stamps it. It authenticates or verifies their signature, sends it back to you for your signature, and then it gives you the fully executed signed document. I'm going to rely on them for the foreseeable future, or maybe forever, to avoid having to have people print and sign and things like that. So the question will become how comfortable you are in not having an original inked signature from your participants in a mediation. You can provide instructions for logging on and for how the procedures work for your virtual sessions in your agreement or in an email or in a letter. I sort of have a hybrid of all three where I give people instructions. Payment arrangements, I think payment arrangements is something that should be in your agreements. When it comes to the virtual setting, I am asking people to provide debit or credit cards in advance so they can be billed at the end of the session automatically. I also ask for a retainer for my private mediations. I know a lot of people who do not do that. I think it's important to tell people what's going to happen if your session is interrupted because of technical difficulties, what you intend to do under those circumstances. I've seen some people use some language about asking people to utilize microphones or earphones. I have a pretty good camera and audio, I think, so it hasn't been an issue for me yet. I've come across a couple of situations where one of the two people in the mediation was on audio but not video, and I haven't yet addressed that in my agreements, but it might be something to think about. I learned the other day that it's not a comfortable situation to have one person be able to see one person and the other person not. And in that particular situation, it was not a technical issue, it was a personal issue. She just refused to get on the video with us together, and her attorneys were involved in that particular case, and I was able to coax her into being comfortable doing it after a while, but it really took a while, and actually they spent probably 20 minutes with me just dealing with that issue alone, which, you know, obviously cost them money. And I think it's important also to let people know this doesn't necessarily have to be in your agreement, but it should be talked about at some point, how you're going to use the mute feature. I'm assured that people speak one at a time. If you've done these so far, you will know that if two people start talking at one time, you can't hear either one of them on these platforms. Same thing with Skype and FaceTime. It's just impossible to hear it when two people speak. So some people I know are using the mute feature and only unmuting people when they want to talk. Excuse me, I've not had to do that yet, but it's possible I will.
Bruce, we
Yes.
have a couple of questions. Maybe I can raise them now. First, will you share a copy of your Zoom Ready agreement to mediate?
I'm happy to, yes. I guess we could send it out, Carl, if
We'll send it out on the listserv to everyone.
I'm going to revise it first because I need to make some changes to mine, but I'm happy to do that within the next day or two. Absolutely.
Okay, and the same thing, will we share our slides? Yes, we'll share the slides. Is there a fee or subscription for Docusign?
So you can sign up. There is a fee. You can sign up for a couple of different plans depending on how many documents you think you're going to need to use in that program for a month. I don't remember the specifics, but I think the basic service is about $10.99 a month for a user. And the next step up is $25 a month. And I'm pretty sure that $25 a month gives you like around 100 a year, documents a year. I need to look into that a little further. To be very frank with everybody, I just started using it 3.5 weeks ago, and I got a free trial. So I've been using my free trial for 30 days. You can sign on and get a free trial and try it out. I don't believe there's a limit to how much you can use in the first month. So I would encourage everybody that before you sign up for a subscription, take advantage of that free trial and give it a shot. And then the last question says, can Bruce put the sample provision in this virtual agreement back up, please? I can. If you give me a second, I will back up. Nope, sorry, give me a sec. There we go. So that is, that's just one part of the language that I've included now. And when we send it out, you'll see I've included payment provisions. I've included a little bit about logging on, a little bit of instruction, very like one sentence instruction about logging on and making sure that people name themselves before they log on. And a couple of other, I put in a provision about video and audio recording and photographs and screenshots as well. So you'll all get that when we get there, in a couple of days, sorry. So I just recommend that even though you're gonna have all these things in your agreements, my experience has been that most of my clients, I don't think, actually read these agreements before they sign them. So I highlight the privilege and confidentiality concepts again at the beginning of my first session in my introduction. I talk about the rules and procedures and logistics for virtual sessions. Now, when I'm meeting with people in my office, I'm just going over my rules and procedures for in-person meetings. I'm explaining the use of breakout rooms and the waiting room so they understand what's going to happen if I ask them to, if I move them into a waiting room or I create breakout rooms. I would say probably for 90% of the people that I've done this with over the last 6 weeks, this mediation was their first introduction to Zoom. or Skype or any other of those in terms of this kind of thing. So they're just not used to these processes. And so I think it's a good idea to go over it with them. You might have some other provisions of things that you've experienced that you want to go over with them in the beginning. And then somebody recently asked me the question is if I do this at the beginning of each session or I only do it at the beginning of my first session. So historically, I've only done this at the beginning of my first session. However, I'm now starting to do more virtual sessions. And so I've started to reiterate a few of these at the beginning of each session, 2 minutes, just reminding people about the privilege and confidentiality and reminding them about the procedures and how I'm going to handle things through the process. Let's see, I think you got a few more questions. Okay, Art just told us there's a plan for posting sample documents. It's a good question, Art. If the client takes 15 minutes figuring out Zoom, is that billable time? I haven't had that experience yet. I had one client, it took her about 5 minutes to figure out her video and her audio, and I did not charge them until they were both on with me. But I tend to be pretty liberal in my billing practice with my mediation clients. I don't bill for every second that I'm dealing with it. So Terry just made a comment about Docusign. She's asking if anybody else has had a problem. I don't think we're going to have that conversation here today, Terry, sorry. But the last question is the Docusign contemporaneous and finished before you start the first session? There's going to be some discussion about that in the question and answers, but I will tell you my own personal view of this is I will not start a session unless there is a signed mediation agreement, either digitally or in ink. I just won't start them without. And we're going to talk about that in question and answers. Tony asked if there's been a problem with Zoom security. I have not experienced any problem with Zoom security in my mediations or my practice. I have in personal circumstances, but I think Zoom has gotten themselves on top of the security issues pretty well. I don't know about Skype or Blue Jeans or the other modes. And Gary Borger, my partner Gary Borger, thank you, Gary, gave everybody in the question and answer screen an explanation of Docusign's pricing, which we're dealing with in my office now. And I think that's it for me, Carl. We're on to question and answers. Do you want to share or do you want me to keep sharing?
No, if you would end your share, I think I would go to my agreement to mediate.
Go ahead.
Okay, so let's do that. Okay, let me just see.
And Carl, when you're done, if people want me to put up my Zoom, I have that separated in a separate document. I'm happy to show them the rest of what's in mine.
Okay. So here is what let me backstep. I created my first agreement to mediate probably back in around 2001, and I was looking around for some sort of template to use. And my recollection is Joan Geiger volunteered to give me hers. And over the years, I either modified it at times or, because of UMA or something else. And I used it for years and years until I retired in some form. So when this issue came up, I looked at it and I was fairly horrified to find out that some of it was just plain wrong. I mean, just wrong. And it just was not that good. So as part of this exercise, I went back and redrafted the whole provision. So these are just separate paragraphs. You want to put it maybe in a different form, but let me go through it quickly. So The first part is that you understand, this is up here, you understand, my thing got in the way here, and agree that communications during the entire mediation process are confidential. You will not disclose the contents of these communications to any third party unless required by court to do so, or to the extent necessary to obtain professional advice from attorneys, therapists, tax advisors, or other similar professionals. That's pretty standard. Now, this issue about caucuses during mediation is one that people have different opinions about. Most people say, if I go to a caucus, everything said in the caucus is confidential unless you say otherwise. Some people take the reverse stand. The biggest problem is it's never been, most people don't put it into their agreement to mediate or in the confidentiality provision. So if you forget to say what the rule is, there is no fallback. There is no confidentiality. And so I'm putting this in as a straw man for you to think about whether you want to put the rule into your agreement, your confidentiality provision. So it says, if during the mediation I meet individually with one of you, which I will only do if you both agree, my private discussion with the party shall be confidential unless that party waives confidentiality. No issue about caucuses and confidentiality. By agreement now, they have been made that way. Okay. Now this goes third paragraph. Only people who both parties have agreed to may participate in an in-person or online mediation session. All people who attend an in-person or online mediation session must sign a confidentiality agreement containing the provisions of this section. So anyone else attends, they have to sign at least an agreement that has confidentiality in it. Let's see. I will select the online mediation platform and will initiate online sessions. That keeps me in control. Parties will hold online mediation meetings in a location where non-participants cannot hear or see the session. All permitted participants will be identified at any time they are viewing or hearing. Okay, online voice and video recordings are not permitted of any session, whether in person or online. Photographs may be taken only with my permission. Now, the reason I put that in about photographs is I often use flip charts, and some people allow photographs of flip charts. What's the difference between your screen and a flip chart? So think about it. Now, this is where I bring in the Uniform Mediation Act. Pursuant to the privilege granted in the Uniform Mediation Act, I have the right to refuse to disclose in court any mediation communication, as that term is defined in the UMA, and may prevent any other person from disclosing a mediation communication of mine. If you try to have me produce documents and/or appear in court in any situation where I have a privilege, you will pay my legal fees in opposing the production and/or appearance. You will also pay for my time in connection with my opposition. Okay. Now, I put this in because I had mixed that in before with confidentiality, and it's really not part of confidentiality, it's part of privilege. So I broke it out here, and I think it makes much more sense. And this last provision is, it's my understanding that as a mediator, I have no obligation to report domestic violence or threats to third parties. It's not true in other states. It's not true of other professions. Psychologists, for example, have an obligation. I don't believe there is an obligation. But I put in here that I have the right to do it. So it says, you understand and agree that if you make a threat or statement or a plan to inflict bodily injury, I have the right to inform the person who has been threatened and the appropriate authorities. So that's where I give myself a right where I don't think I have an obligation. And if I didn't have an obligation and I did it, do I open myself up to any potential liability? So that's why I put it in here. Also, I'm required to report if I have a reasonable cause to believe that a child has been subject to abuse, acts of abuse or neglect. So this is how I've redone mine. It's a work in progress like everything. I'd be glad to send, this is going to go out to the listserv so that everybody can see it. And if you make changes to it, I would appreciate it if you either resend it to the listserv or send it back to me. Although I don't mediate anymore, I want to know what everyone thinks about the right thing to do. Okay.
Carl, can I add? I just want to. So I think it's important to remind everybody that some of this is personal. Some of it is very much how you feel. Like Carl added that last paragraph about mandatory reporting in certain circumstances. I think you have to search your own conscience and your own sensibility to determine what you want in that agreement and whether you're willing to negotiate certain provisions out of agreements if people ask you to.
Right.
So I want to address, there's a few other questions that came up right before you started that. Anju asked if I or you, I guess you're not anymore because you're not doing mediations, but a free half-hour consult. I have just started offering mediation clients a free half-hour process consultation where I will just talk to them about the mediation process if they need, if they want. I've done it twice in 2020 so far. Margarita asked, have you purchased Zoom Pro or Zoom Business? We purchased two versions of Zoom Pro for our office because several of us are doing online mediations at this point, and it's just like using a conference room. I can't use a conference room for two different mediations at the same time. I can't use my account for two different mediations at the same time. So we are managing it that way. I don't think as mediators we need we don't need the things that Zoom Business offers. I think it's for like hundreds and hundreds of people, and there's all kinds of other things that Zoom Business offers. I don't think it's necessary for mediators, but I'll be very honest, it was a long time ago that I signed up, so I don't necessarily remember it all. Thank you, Adam Berner, who referred us all to a different option for digital signing, which is called HelloSign, which he said was a better price. I'm going to look into that. Thank you. And Carl, the question, you got that? Anju made a comment that her client signed the agreement to mediate and she signs it and shares a signed copy with the party, so she doesn't need to use Docusign. Again, I'm only using it because I found people don't necessarily have the ability to print, scan, and return it to me from home. And so it's easier to do it through the digital. Especially, I've had some recent cases like this morning where they just got referred to me last week and they needed a session really fast. And to get things done by email, scan, things like that was going to be need to be a lot quicker than we could get it done. And Gary asked, when you identify caucus discussions as confidential, do you mean not to be disclosed to the other party? I think that goes to you, Carl.
Yes, yeah, exactly.
Right. All right. So you ready to get on to the question and answers?
Okay, so let's go back. I'll go to question and answer here. Let's see, where am I? Okay, so let's see, we'll go to the question. Okay, questions and answers. Okay, first question. Bruce, for you.
Okay, so after I've completed a mediation, the parties fail to reach a binding agreement and are in court. They both waived the UMA privilege and want me to testify in court. I think that my testimony will help resolve the matter quickly and fairly. What should I do and why? I would likely choose not to testify because I have a very strong sense of maintaining the sort of sanctity of the mediation, and that I don't want it to get around that I'm willing to testify in court about things that happen in mediation. The second thing is there seems to be a part of that question of that leads me to the concept of patriarchy and matriarchy, where sometimes we as lawyers and mediators think that we're going to be able to solve things for people who can't solve it for themselves. So thinking that my testimony will help resolve the matter quickly and fairly seems to me to be something about myself and not necessarily the parties or their own issues. I just don't, I think you can. I think the statute clearly allows you to do this if both of the parties are consenting to it. I just don't think it's a good idea, and I don't think I would do it. And I'm clear with my clients that I will not testify in court even if they both ask me to, that I will not do it.
So other parties, let's ask people what they think. So does anyone else have a different opinion on this question?
Which means I think if you want to raise your hand.
Raise your hand. And somehow I can't see hands raised, so you're going to have to answer it.
I think I'm saying Art Lieberman raised his hand.
Okay.
So I'm going to let him talk.
Yes.
Yeah, hi. So I'm thinking if they're going to court and you think you can be helpful to it, then invite them back to mediation. For one, you shouldn't be saying it in court. And secondly, if you're probably going to be helping, then it's going to feel like you're taking somebody's side, and that's going to anger the other person. I think you should not be discussing this outside of the mediation room.
And that goes with your reputation. I think it starts to taint your reputation a little bit in the mediation community.
Yeah.
And the legal community. All right, thanks, Art. Anybody else want to add anything to that?
Does anyone think it's a good idea? In any circumstance, would they do it? Raise your hand if you think there is some circumstance under which you would do this.
Yeah, I'm not seeing any hands raised, Carl, so I think you can go on to the next question.
Okay, so let's go to the next question. By the way, that's the Willingboro case, where the mediator, all three parties, because they waived privilege, went to court thinking this was the best thing to do. And of course, no good deed goes unpunished. Okay. This one, contrary to the confidentiality provision in the agreement to mediate, one of the parties made a recording of the Zoom mediation snippet session. Snippets of that recording showing you are then put on Facebook. Do you, as the mediator, have any remedy? Answer. Someone raised their hand, and let's get a. And again, Bruce, if you could do it, I've somehow.
I could see people raising their hands.
Okay.
Anybody want to take a shot at an answer to this question? You're getting nobody offering here, Carl. Sorry.
Nobody's offering a okay. Well, I think we do have a remedy. It's a breach of contract, right? Is it a realistic remedy? But in the sense, is it realistic? Because let's see, Gary Borger, is that who?
Gary's raising his hand. I will give him the microphone. For some reason, it's not allowing me to unmute him. So Gary, see if you can unmute yourself.
Yeah, he has to unmute himself.
Doesn't look like he's getting to that.
Okay. So, would you do anything? Would you, as the what would you do as the mediator who's whose video has now been put on to, has been copied and been put on Facebook.
All right, I think Gary's able to talk now.
Okay.
Gary, can you talk?
Yes,
All right, there you go. We can hear you now.
I agree with Carl. You have a right to pursue a cause of action for breach of contract because you are a party to the contract. Is it realistic to pursue it? Probably not, for a lot of reasons. One, you have to prove damages, and that they can really be speculative in terms of what it cost you in your reputation, future lost business. So that's one reason you're probably not going to get an award that's meaningful. Number two, do you really want to go through that yourself and engage in litigation over something that damaged you in some way, but it's not really provable, and begins a process you may not want to enter into?
Okay. I have a suggestion. I was thinking about this while I was lit. We have another hand. Someone else?
Yeah, Bradley.
Okay. Can you turn?
I did. I'm having the same problem with the unmuting option. I've enabled him to talk. Oh, there we go. Bradley, say something, please.
Can you hear me?
We can. Thank you.
I think you can do absolutely nothing. I think that in terms of a breach of contract, you'd have a very difficult time getting any kind of realistic damages, and you're just going to end up removing yourself from the case. You're in it as a contractual neutral. You're not supposed to have a position. And if you're angry that it's been placed on Facebook, or you believe that the agreement's been somehow breached, I don't know how you can continue as a neutral. And if you've already done the process and the things are mediated and not successful or successful, you have no additional contact with the folks anyway. I think you just have to walk away from it and keep your fingers crossed that it doesn't go viral, quite frankly.
Okay.
So Bradley, you're one of the parts of that answer talked about if you're in the middle of the mediation, which I think is a different question than at the end of the mediation when it's already concluded. I think I would say if you're right, if it's in the middle of the mediation, it's an opportunity to step out of it and say, I can't continue to mediate this. You violated our agreement. And it gives you the ability to say, I'm not going to do that anymore. I think Carl's question more addresses what happens if it happens after the mediation is over.
Yeah, I think you can't do that. I think you're stuck, quite frankly. I don't think you can do anything. I don't think you're going to be able to alter what's already happened. You can't take it off of Facebook. There's really no remedy. You're not going to get damages. I think you have to walk away.
Okay. Here's something I was thinking of the other night. And how about if you put into your agreement to mediate in the confidentiality section, or that section that had confidentiality, et cetera, a liquidated damages provision. So it says something like, if someone makes a recording and makes it public, then the party shall be subject to $15,000 in liquidated damages. Any thoughts about that? Which would allow you to get a special civil. You don't have to prove damages because it's been liquidated per agreement. Any thoughts?
So there are two hands raised, Gary and Margarita. I don't know if their hands are raised in relation to that question or something else. So I'm gonna let Margarita speak. Okay, there you go.
Yeah, my comment was earlier than the liquidated damages proposal that Carl just raised. I thought that the objective would be to get it down from Facebook. So I agree with the other members of the organization that it would be very difficult to prove damages, to bring a breach of contract action. But nevertheless, they have breached the contract, so that you can write a letter to them and tell them to bring it down, bring the Facebook post down, based on the fact that they have breached the contract, and hope that that works.
So a few people have commented in the chat and also in the Q&A that Facebook has a mechanism where you can file a complaint and ask for it to be removed. And I don't know the rules. I'm not big on Facebook, but it is certainly a possibility to contact Facebook and ask them to have it removed as a possibility. Carl, do you want to move on? Or Gary also still had his hand raised.
I'm sorry, who does?
Gary Borger.
What does Gary have to say?
We're gonna, yeah, I think nope, sorry, I got the wrong one. Gary. There you go. Gary, go ahead. Or is your hand raised from before, Gary? All right, I'm not getting.
Okay.
Yeah, I'm not getting him back. So, all right, ready to move on here?
Yeah,
All right, is this one yours or mine?
that's yours.
Okay, so you caucused with one of the parties during a Zoom mediation session, but failed to set forth the ground rules as to confidentiality of what is said during the caucus. Is the caucus confidential? Is there a default in that everything said is confidential? So I think there are two questions here. One is it confidential in general in the sense that it is part of the mediation process? I would argue that everything that happens in the mediation, if it is put forth in the agreement in a confidentiality section, whether it's said in caucus or in a group session, is confidential in the grander scheme of your agreement. The question becomes, can somebody tell you something in a private caucus that they want you to keep confidential from the other person? That's where I think you need to set that ground rule ahead of time and tell people whether or not it is okay for them to tell you something in caucus that they want you to keep confidential from the other person. I think if you don't have it in your agreement, they have a legitimate right to assume that it is going to be confidential, and they can tell you that. Therefore, I think it's important that you address it ahead of time. Oh, sorry, I forgot we were going to ask people. Sorry about that, Carl.
That's all right.
We were going to ask people to chime in. Sorry,
Yeah.
Does anybody else want to add anything to that? If you do, raise your hand. All right, seeing no hands raised, Carl, why don't we go on?
Okay. This is yours.
Okay, I promise I'll ask for hands this time. You give the parties an agreement to mediate at the beginning of the first session and tell them to bring it back signed in the second session. Is anything that happens during the first session confidential? Are you as the mediator bound by confidentiality even if the agreement to mediate is not signed? Why, and what would be the remedy or for a violation by you? Does anybody want to give us their thoughts on that? Brad, raising his hands first. So it's first come, first served. I can't get you unmuted again, though. I don't know. Oh, there you go. Okay, go ahead, Brad.
I think the realistic fact is that when you sit down with people for the first time, whether or not this agreement is signed, you're telling them it's confidential. You're telling them the standards by which the discussion is going to take place, and accordingly, it's going to be confidential. You just don't have proof that the agreement has been agreed to because you don't have a signed document, but you'll have an oral understanding and an oral agreement that it's confidential. I guess it would be a question if you don't talk about those things, and then is it confidential? And I would respond to that by saying, I think you have to talk about confidentiality at the first session, whether there's a signed agreement or not.
Okay, we got one more. Give me a sec. Gary, I think Gary Borger wants to chime in on this one. Gary, there you are.
No, I think my hand was still up from before. I couldn't get it down.
Yeah, I don't know how to, oh, there you go. I got your hands lowered. Thank you.
Okay.
While I agree with Bradley in theory, I'm not willing to take that chance. I will not start a mediation without a signed agreement. I think that is good practice. I will do a consultation, as long as we're not talking about facts and issues and just process. And I do talk about confidentiality at that time, but I just think it's a bad idea to start a mediation without a signed agreement.
Right. Okay, sorry. I agree. I think it's dangerous to do it. On occasion, I haven't. Never had a problem, but that's not to say it's good practice and that you won't. I think you should have it signed before you actually start. Okay. Okay. This is a series of 3 questions, and I'm going to, let me read the question. You're in a session covering parenting plans. You've taken notes, and almost all items have been resolved except for one point of relocation. The client asks if you would reduce your notes to writing and send them because they didn't take notes. What do you say? Okay, so that's the first question. The second is, same as above, but you have written everything on a flip chart at the end of the session. The parties ask if they can take a photo of the flip chart. Does anyone disagree? Does anyone not allow a party to take a photograph of a flip chart that you created during the mediation session? Anybody?
I do not see any hands being raised here.
No hands. So everyone allows that? Okay. Now, how about if the party, you ask them, do they want to take a photograph? No one says anything, so you move along. And a week later, one of the parties calls in and says, you know, my notes aren't as good as I thought. Could you take a photograph of the flip chart and send it to us? Would anyone not do that? If you wouldn't allow them to do that, raise your hand. Do we have anyone?
I don't see anybody raising their hands to that one either.
Okay, mediation's now done. The memorandum of understanding is complete and the parties have it. It's a month later and one of the parties says, now you said you would take a photograph of the flip charts on parenting. I would really like to have that now. Would you please send it to us? Is there anyone who would not send it to the party? Anyone?
Still no hands raised.
Okay. Oh, now we have one.
Up, Teresa. Hold on. Teresa, I'm trying. There you go.
There we go. I would think that you're opening up a can of worms by communicating with one party after everyone agreed they were finished.
Oh, let's make it clear that if one party asks for it, you'll send it to both of the parties, all the parties.
I think I would evaluate the situation and again, see if this reopens wounds and creates an ongoing issue. But I think I would still be careful to say, we're finished, this is done. I remember the court mediations when people would follow us out after they did not settle in court, went before the judge and said, can we talk now? I think it's clear to establish you're finished.
Well, okay, so there are 2 more questions.
Yeah, there's 2 more hands raised. Well, there's 1 more hand raised here.
Okay, well, let's find out what they have to say.
All right, give me a sec. I got David Riley. Yeah, the unmute doesn't seem to be working for me, so try to unmute yourself.
Okay.
Oops. Oh, there you go.
Okay. For me, the issue is in the hypothetical you've indicated the mediation has been concluded, the MOA has been signed, and the parties are now on their own. I wouldn't be retaining copies of notes or flip charts as part of my file, so I just simply wouldn't have them available. So I think there's an issue there of what does one retain once the mediation has been concluded.
But
I
let's
typically
let's
retain,
assume you did have it. Would you give?
appointment, retention letters, things of that sort, but not notes or other details of the mediation session itself.
If you had them, would you give them?
If I had them and the parties, the understanding right throughout the mediation process was that they were free to take photographs of them, in all likelihood I would, but I'd want to make sure that it was a joint request.
Okay. Any other hands?
Yeah, we got, give me 1 sec. I got Margarita.
Share the notes.
No, these aren't notes. This is a photograph of a flip chart.
I wouldn't share the notes. I wouldn't share the photographs of a flip chart. It sort of goes against the grain of the confidentiality provision that they've already signed in the agreement. Whatever happens in that process is confidential and is your property, is the mediator's property. And so it's not anything that would be shared or would be kept.
Well, let's assume it's kept. I don't understand why it would violate confidentiality, because confidentiality says that the parties, which have access to all the material during the mediation, won't distribute it to third parties. And this isn't going to a third party, it's just going to the parties. So I don't think it's a confidentiality issue. So if you would do it during the mediation, and you would do it shortly afterward, presumably, why wouldn't you do it later?
As I said before, I think that the process itself is, that work product, if you will, is part of the maintaining the confidentiality of the process. Despite what I understand what you're trying to point out, Carl, but once you reach finality of the process, it's not anything that you would retain or anything that you would share.
Well, first of all,
in addition to which, the agreement that they have presumably entered into would include elements of those notes. So what would be the purpose of sharing the flip chart and or the notes?
well, the reason they want to have the flip chart is because the UA signed, not signed, the UA is completed. It's not signed or binding yet. And they're taking it to their attorneys, but they want to make sure what they just talked about during the session on parenting, et cetera. So they just want to have that before they go and make it final as a part of a marital settlement agreement. And so, again, the point is, you would have done it during the session, during the sessions. The UMA is not binding, and they want to have it, and it's still confidential. There's no question of confidentiality because it's only between the parties, so why not give it to them? You have it, why not give it to them?
So
I would fall back on what I said earlier, that presumably it's already been incorporated into the UMA.
That's presumably correct, but the question is, why wouldn't you give it to them?
So it sounds, Carl, it sounds like you're advocating for the fact that as long as it's just the parties, they're entitled to see anything that was prepared or used during the mediation session, because everything that you're talking about is subject to confidentiality, but they're subject to the confidentiality, so they're allowed to see it. Am I correct?
By the way, I've never seen an agreement to mediate that says it expires at a certain point.
Interesting.
So let me take it a step farther.
Well, before you go there, hold on a second. We have one more person who wanted to say something. Teresa,
Yes, I'm
Not even
again,
gonna try on
Carl.
your last name, sorry.
That alphabet, A to Z.
A to Z. That's a good one. I like that.
I think sometimes, particularly when it comes to the marital and child situation, there are some people who will use that as an opportunity to keep revisiting. And there has to be a point where you say enough and you make it very clear that all parties are responsible for taking their own notes and photos if those opportunities are offered, and that you're not revisiting, because for some people that's an opportunity to keep reopening and keep it going.
Okay, let me address that briefly. This is the parties' mediation. The parties are in charge of the process, and they have a right of self-determination. I don't see where the mediator has a right to say, well, I would do it then. I would let you take a photograph when I offered it to you. But now there's come a point where I won't do it anymore because what? I don't think it's good for you. I don't think what? Now, let me take it one step farther, and then I'm going to go back and say what I think the issue is. Now the parties are retained attorneys and they're going to litigate. And they ask for the same photographs of the flip chart pages. Would you give it to them? And to me, the only distinction between any of these points in time is whether it's still confidential and whether it's still privileged. It's always confidential if it's between the parties, but you have this question of, does the agreement to mediate still cover it? And why there's no explicit waiver of privilege, which means even if you provide this, they can't use it in court because it's privileged, you might have some concerns. So I would do it at any stage because I was willing to do it at one point in time, but I would make sure that the parties acknowledge that it's still covered by confidentiality, which means they can only use it, they can't divulge it to third parties, and that there is no waiver of privilege, that they acknowledge that it's still privileged, which means they still can't use it in court. So absent that, if I were willing to do it then, I still have it, I would do it. Of course, they got to pay me for it. So that's how I would come out about it. Now let's go back and just briefly talk about notes. Do we have any psychologists listening to this? If so, could you raise your hand? Bruce, do you see anyone?
I do not see any hands raised.
Other mental health professionals? Ray Bloom, I saw yours.
Ray Bloom's hand was raised for a minute, but he took it down, so I don't know where he went.
Okay. My wife was a psychologist, and she says during her education as a psychologist, they are trained how to take notes. They only put certain things in their notes, and that they have an obligation to provide a summary of notes if a client requests them. So we went through this scenario with using a flip chart. And in the session, I often use a flip chart, and I would write everything down on that flip chart. You know, what was agreed to, what was proposed, what might be the problem. You know, Joan says, don't want to do it because, etc. Now, isn't that the equivalent of the notes I would take if I weren't using the flip chart? And so what's the difference between giving those notes or a summary of those notes instead of letting someone take a flip chart? I'm just throwing that out as a question, because I've heard people say, no, my notes are sacrosanct. But you use your notes to create the MOU. And so don't they have, the parties have a right to see at least a summary of them? Okay, now I see some hands.
Carl, before we get to, there's a couple of hands, but I just want to add that you and I had this conversation. I was one of the people who had told you that my notes are sacrosanct. And I still struggle with it. And so my feeling is I wouldn't copy my notes and send them, but I would paraphrase them and tell them what's in there. I also want to add that if I'm going to send people after the mediation or even during the mediation, anything like a picture of a flip chart or something like that, I am always reminding them of the privilege and the confidentiality of the mediation process in that communication, so they're reminded of it. So, so just real fast before we get to the hands, Adam Berner raised a question about requiring us to maintain notes as a result of Rule of Professional Conduct 2.4, the lawyer serving as a neutral. Do we have a requirement to retain them for 7 years? We haven't prepared to discuss that, Adam, so I think we're going to leave that for another webinar at another time. Sorry, we're not going to specifically answer that question. But let's go to Ray, because his hand has been up for a while.
Okay.
And let him, and then we have Anju and David, and then we have one more question to get to. So Ray, you should be, I'm trying to unmute you, but I'm not having success again doing that. There, no?
Ray has to unmute himself.
Ray, try to unmute yourself there.
Hello.
There you go.
Hi.
There you go.
Hi. Yeah, so I'm a licensed marriage and family therapist, and my wife is a family lawyer, and we do co-mediation to balance gender, and we provide a summary of what was discussed in each session to clarify what the understanding is. So some people take notes in the session, some people don't. Sometimes there's an imbalance of the who does what in the marriage. And so just to get everybody on the same page, we send that information out. If there's any discrepancies about our understanding of what was discussed, we will discuss that in the next session, or there will be questions that will be done in between the sessions where each party is privy to it. And so just to clear up any ambiguity. The other thing I did want to ask was, does everybody get their MOU signed? Because we haven't.
Nope.
And
I think the rule is, or should be, that nobody signs an MOU in your presence. The mediator should never sign it, and you shouldn't allow anyone else to sign it in your presence. That's, I think, the proper way to do it.
yeah, we don't. So.
Yeah.
All right, so Gary is telling me that he can't hear the attendees when they speak. Other than Gary, is anybody else having that problem? If you're having a problem hearing the other attendees, can you raise your hand? I know that Anju, David, and Gary have their hands raised. But okay, nobody else is having that issue. So Gary, it might be you, your computer, not ours. Carl, we got 3 hands raised. We're starting to get close to the end of time, and we have another question. So how do you want to proceed from here?
Well, let's go a little bit more, and we have 7 minutes. Okay.
All right, I'm enabling Anju. Unmute yourself, and there you go. Up.
Can you hear me now?
Yep, you're good.
All right, so my notes may say something like, there may be an alcohol issue.
Uh-oh, sorry, Anju. Anju, unmute yourself again.
Can you hear me?
Yeah, sorry. We heard you start, and then I cut you off by accident.
All right, that's fine. Thank you. I know it takes a while to learn the technology. So to keep it quick, my notes have points like there may be an alcohol issue. I'm not going to put that on a flip chart. So I don't consider a flip chart or a whiteboard the same as my personal notes to myself. Because I only use a whiteboard, I don't use a flip chart. If you don't take a photograph, then it's gone. And sometimes though I take a photograph, but I find when I take a photograph, the clients take a photograph as well. So I haven't had that experience that I found if one person takes a copy of a flip chart, everyone wants a copy of it. So I haven't had that experience, but I have had the experience where I shared a document in the mediation, someone didn't have it, and then they asked for a copy later. And I just make it a point that if I send anything to one party, I try and send it to every party. That way no one says later, why were you having these one-off conversations? That's it. As far as
Okay.
Okay.
Well, Anju, I would think that if you're going to give a summary of notes, which I think is the proper thing to do rather than actually sending your notes, that you would not include that because that's not something that happened during the session. That might be an observation, but it's not something that happened during the session. That was your personal observation. You wouldn't put that in a summary. So
I will say this, every now and then I will do a summary, and no, summary is not going to include my observations. The challenge I've had with summaries is that once you send a summary out, you have one client who has to correct every statement you've made. And so I'm very cautious about that. I rather in a email to clients, really bullet point it very briefly and more talk about next steps. So I'm, you know, there's, right, as you said, no good deed goes unpunished. And those summaries for the client, especially the litigation-oriented client, he's going to question every statement in there. So, okay.
okay.
All right, we got one more. We're gonna, David Riley. Just let me make sure you're there. Sorry, David, hold on. Sorry, I just messed up again. There you go. You're good.
All right, I don't want to repeat too much, but to the point that Anju was making is I would never use the flip chart as a substitute for notes and really use it more as simply a visual for the parties to see what they're talking about, an outline of some sort, but I would never have my own comments, and my notes oftentimes will have mental impressions, will have little side notes of things to follow up. And so under no circumstance would I ever yield my notes. Also in the interest of full disclosure, most of my mediations are labor, employment, and commercial matters. And I also would not provide a summary of my notes. I think there you then start getting into negotiating the notes. I think it can be done verbally if there's multiple sessions to sort of recount where the parties are in terms of their level of agreement and open issues. But I would be very reticent to ever providing summaries of notes, let alone, and certainly not the notes themselves.
Okay.
Great.
So let's move on to the last, I think this is the last one.
Yep.
You as the mediator have prepared the balance sheet. The parties don't understand how you arrived at certain of the entries and want you to explain. Would you do that?
So you were asking the group to raise their hands on this one?
Yep.
Anybody want to take a shot at this one? All right, I got Linda Spiegel. Linda, go ahead.
Definitely. You want them to understand how you got to the bottom line, and it's based on the information that they've given to you. And it's going to go into the MOU. So I would, of course, explain it to them.
Okay. Now the mediation is ended. Well, I shouldn't say ended because we don't know what that means. But in any case, they reached the point where an MOU has been prepared. Everyone has said, yes, that is the MOU. And a month later, the parties ask you, could you explain how you got to the balance sheet, how you prepared it? Would you do it then?
Sure, we'd set up another session, and during the session, I'm available to answer any questions that they have. So I have no problem with that.
Is there any point in time where if the parties asked you, you wouldn't do it?
Only if I no longer had my file and couldn't remember what I'd done, and then I'd explain that to them.
Okay. I think that's our last. Does anyone disagree with that? Hearing none.
We
Oh,
got
we have one hand.
one person there, Bradley. Hold on a sec, Bradley. I'm going to give you.
He has to unmute himself.
Yep,
There.
you're good. Go ahead, Bradley.
Okay. I do a lot of work with lawyers. And as such, when an individual litigant calls me, I refer it to counsel because I think that's my obligation. So if I were to receive a request to explain an MOU, I would suggest to the litigant that they speak to their lawyer. And I would be very hesitant to talk to the litigant separately or to the litigants together separately. I think it would be a breach, at least for me as a lawyer, of my ethical obligations.
So I agree with what you just said there. The way that I handle that is if somebody asks me, I want everybody on the phone, or if I'm sending an email or a letter, I'm addressing it to everybody. If somebody calls me and asks me for an explanation of something, and the other person says, I don't care, you know, I don't need that explanation, I still want them on the phone. I still want them to receive a copy of the email or the letter, so that there's no question that I'm not having any kind of unilateral discussions with one particular party.
Okay. Anything else? Does anyone want to say anything else? If you do, raise your hand.
All right, Bradley looks like he wants to say something else. Go ahead. I think I unmuted you.
Brad, you have to unmute yourself too.
Unmuted. All right. I am a little bit older than I like to admit, and this is the first time I'm doing one of these seminars or webinars. I think it's awesome. I think the information that we've just spoken about, the different views, great to listen to, and I'm going to be doing this a lot more. So, guys, thank you for putting this on.
Thank you.
Glad you enjoyed it. And there was another hand?
I thought I saw Adam Berner, but I'm not sure. So, nope, doesn't look like Adam raised his hand. So I think we're good.
Okay. Well, I think this went well, by the way. We're just about on time, just a few minutes over. I hope everyone liked, this is the first interactive webinar that we've done. I always like to do these because they're a lot more interesting than if you just lecture or interview or whatever. If you like them, you like this one in the interactive feature, we can certainly build it into our future webinars. So, Bruce, I want to thank you a lot.
Thank you.
Really enjoyable. And I want to thank everyone else who was part of this today. I hope you enjoyed it. And now I have my big outing of the day where I'm going to Ace Hardware, where they will bring something to the curb. And this is my outing of the week, I think. So take care, everyone.
Thanks, Carl.
And again, if anyone has any ideas for a webinar, wants to be part of a webinar, please let me know. We need your suggestions, your involvement to make this all work. So I look forward to hearing from you. Thanks a lot, and everyone have a great day.